Welcome back to Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We are pleased to have back in the studio Roger Wintle. Roger, welcome back.
Thanks for having me.
You are the real estate board attorney, well, they call it now the Santa Clara County Association of Realtors.
Correct.
And you've been doing that 3 or 4 years?
Yes.
I attend your seminars.
Thank you.
No one gets up and leaves except me.
That's right.
I come and go as I
please. You're the only one I allow
I
to
disturb your class. And I know you started teaching. That was your first career?
Right. Out of college, I studied to be a teacher, and I taught, as a matter of fact, elementary school. And I was actually a headmaster of a couple of private schools. And then at some point in my life, I had this inspiration to go to law school. And I did after, I probably was 30 years old when I went to law school. And it was quite a shake-up to go to law school after being in the working world for a number of years. But you know, one of the things I've always said is, having been a teacher and learning and having learned how to put together lesson plans and try to teach so that people understand what you're saying. You know, lawyers have this tendency to speak their own language.
Absolutely.
A lot of Latin words. If you ever stand around two lawyers talking to one another, it'll drive you crazy. Yeah. But you can't talk to your clients that way because it's sometimes hard for them to follow. So you've got to boil it down to something that they can understand so they can communicate with you effectively and then make effective decisions. So I think the teaching has actually helped me. I've ended up teaching college courses as a lawyer, and they're a lot of fun because I love the give and take with the students, and it's been a real inspiration for me.
Okay. Because I know when you're teaching these concepts to the real estate community, it's in a layman's terms so that we can help our clients get through this mess.
Right.
Now, speaking of which, tonight's topic is foreclosures.
Okay.
Now, we have different names for foreclosures. For instance, I like to use the term, now I'm using the term, repossessing the home. That seems like people understand that.
Sure.
Okay, the bank is repossessing the home.
Right.
The other part is, now, there is an actual sale of a house on a courthouse steps.
Correct. Well, let me break it down to you. When you get a loan, the loan itself is, you have a promissory note that shows the amount that was borrowed. Mm-hmm. But that promissory note is secured by a deed of trust.
Sure.
And that deed of trust is in favor of the lender. That secures the repayment of the loan. And so there are three parties in that deed of trust. There's the lender who makes the loan. There's a trustee who has the authority under the deed of trust to sell the property in the event the borrower, who's the third party, does not make the repayments under the note. So what happens is, if you stop making your payments, and you probably have a longer period of time than at any time in recent memory before the lender will actually start the foreclosure process.
Right.
You're not going to miss that first payment and have the lender file for foreclosure. What you're going to have is, after you miss a couple of payments, they'll probably send you a letter saying, you know, you're not making your payments. What can we do? We want to work together with you to make sure that you stay in the home. And then the borrower at that point might try to do a loan modification or some alternative method to stay in the home. But if that doesn't work, then what the lender will do is file for foreclosure. And there's a two-step process in foreclosure. Under every deed of trust in California, there's two steps. There's an NOD, which is a notice of default. Mm-hmm. And that's the first letter that comes to the borrower. And it says, you are behind in your payments, and here's the amount that you're going to need to pay in order to reinstate your loan. And if you pay it within the next 90 days, all will be forgiven, and the loan is reinstated, and we'll just go on like nothing ever happened. And that's a pretty lengthy period of time. But usually, by the time you get that letter, you're already 3, 4, 5 months behind, and you're not paying because most likely you can't pay. Your wife has lost her job, you lost your job, you've got a cut in pay, I met a guy who had a problem. He was working a union job in San Francisco when that was over, and making good money. And when that was over, he went back to the Central Valley where he's making half as much, and he couldn't afford to pay his mortgage, and there was some sickness in the family. I've heard it all with people who've gotten into trouble. It's usually not they don't want to pay, it's that they can't pay.
Exactly.
But in that foreclosure process, after that 90-day period runs, then you get another notice. It's an NOS, or notice of sale. And at that point, the lender notifies you that the property will in fact be auctioned off at the courthouse steps, and they'll tell you the date and they'll tell you the time. And what happens is that trustee that was appointed in that deed of trust, or an alternative trustee if the bank so chooses, will stand on the courthouse steps. I actually did this once. It was kind of fun. I was named as a trustee on one of my clients' deeds of trust, and I stood on the courthouse steps wondering if anybody was going to show up. Yeah. And you auction the property off to the highest bidder. Now, what you'll notice if you go down to the Santa Clara County Courthouse when they're doing this, there's a lot of people stand around seeing what's going to happen, because there's these big lists of foreclosure properties, and there's whole cottage industries of helping people try to buy at foreclosure sales. There's situations where somebody might just go down and see if they might be able to bid in. It's a very complicated process. You just don't go down there with your checkbook in hand and bid in, because you have to have cash.
You better know what you're doing.
Yeah, and you better have cash too.
Right.
You know, different denominations of cashier's checks. So the bank or the trustee for the bank will sell that house to the highest bidder at the foreclosure sale, and when they determine who that is, then they'll make a trustee's deed. That'll be a deed from the trustee to the buyer, and now the original borrower, the folks that are in the house, are off title to the property. Mm-hmm. And that's where the fun begins, or at least the complexity begins, because you've just lost your home, and the bank is either been on title or going to be on title as the new owner, or somebody third party has bought it. They want possession of that property. If you're the bank, you want to get possession of the property, you want to secure the property, and then you want to hire your local real estate agent to sell that property for you as an REO, or real estate owned property. If you're the third party, you want the same activity to occur. You put money up, you want that house, it's now yours by virtue of the trustee's deed, but you got these folks in the house. How do you get them out?
How do you get them out?
Yeah.
Exactly.
Well, what's going on now is you're seeing cash for keys, where the lender or whoever the highest bidder is at the trustee sale will knock on the door and say, you know, I'm now the owner of the property, and I know this is really hard for you, but we want to work out some arrangement for you to move. You can't make this an adversarial thing, because they're already in bad enough shape and feeling bad enough already because they lost their house. So you say, well, what is it going to take I want to give you some money to coax you into moving, and what is it going to take? And then you negotiate, and there's probably a standard fee. I don't know what it is, but I'm sure there's a standard fee to get people to move. That helps them with the moving costs. That helps them with getting out of the house and adjusting to their new life. You know, I had a case a couple of years ago where there was an actual foreclosure. The bank had foreclosed on the property, and they were on title, but the bank didn't get involved in the nitty-gritty of securing the house, so they hired a company to do that. Right. And their sole job was to get possession of the house, get it secure, change the locks, so the guys can't come back in,
sure.
Then hire the real estate agent who will sell the property. Well, what happened in this particular situation is the foreclosure occurred. The company that was supposed to secure the property went out, and when they went out, some guy came up and talked to him and said, you know, I'm renting a bedroom in this house, my son and I, and we pay rent, and we have no idea what's going on here, and why are you doing this, and how come I can't get into my bedroom? And the company said, well, you know, I got orders to secure this property and to change the locks, which is what they did. And then a lawsuit ensued, because the man who thought he had tenants' rights got a lawyer, and the lawyer sued the bank, sure. And the lawyer sued the company that secured the property, mm-hmm. And as luck would have it, he sued the real estate agent and his broker for being involved in this process.
Of course.
So he had a big mess. and it took a while to unwind this thing. And we ended up paying the plaintiff, in this case the man in the son, a modest amount of money to get him out. But those are complexities that can happen in a foreclosure sale, unforeseen issues where you as a real estate agent all of a sudden are pulled into something and you didn't see that coming, and all of a sudden you have to defend it.
Right. Now, a lot of these homes, how it started, they bought the home years ago and then continued to refinance and pull money out, refinance, pull money out. Then it became a short sale. They tried to sell it as a short sale with lender approval. That didn't happen. And then it went into foreclosure that you just described.
Right.
So once it comes out on the other side, and then, so when it's during the short sale process, they have XYZ real estate company trying to sell it in one city. And then when it goes through the foreclosure process, the bank hires a new realtor from a new firm, from a different city, and now they have possession of the house and it's vacant.
Right.
Okay.
Now that new agent, typically the banks have their, what I call the most favored agents that they use. And those guys are doing just multiple transactions for the bank, probably at a reduced commission rate.
Dozens.
Yeah, but the banks know that they can trust these people or have some faith and confidence in them. And those folks are the ones that are going to end up selling that REO property. But during the time that they're trying to sell it, the law imposes certain obligations on a property owner. So as an agent, you have to make sure certain things are done. You can't let the swimming pool in the backyard turn into the Black Lagoon.
Right.
You got to make sure that the lawn is cut so it doesn't become an eyesore and attract nuisance from the neighborhood.
That makes sense.
So you got to have all of that stuff done, and if you don't do it, then most cities have ordinances that say if they have to hire somebody to do it, they slap a lien on the property to get paid when the property eventually sells. So it gets a little complex, I think, for the REO agents. The other thing that happens a lot of times, I had a client who had their property, they had a rental property that was subject to foreclosure. And they had constantly people breaking in to that property. And so they're breaking the windows and coming into the property after it's foreclosed because they know it's vacant. And so it's mostly vagrants, but then they open the door for their buddies, and then pretty soon the whole place is full of people, and then you got to deal with that.
Sure. Now, in terms of the alternatives, families facing foreclosure, what are some of the alternatives? Well,
my favorite alternative for many, and for many reasons, is the short sale. The short sale is a process whereby the property, the debt on the property exceeds its fair market value. So if you say I'm going to sell it, then either you have to do one of two things. You have to pay the entire indebtedness on the property, which in most cases, in all cases in a short sale, you can't do because you're not going to get enough money to pay off all the loans. Or you do the short sale, which is you ask the lender, I want to sell this property, and I want you to take less than you're owed. But what's the benefit to the lender? Well, if the lender accepts the short sale offer that comes in, and they'll investigate what they think the fair market value is, then they don't have to go through the foreclosure process at 90 days and then another 20 days that I just described. They can sell it hopefully sooner. They don't incur the cost, because when you do the foreclosure, you have to pay the trustee. You have to get a foreclosure guarantee from a title company. You have expenses along the way. You can avoid those expenses and the time associated with foreclosure by doing the short sale. So, but what you do with the short sale is the seller is going to walk away from that house with nothing, because under the short sale, the lender's not, the borrower, the seller, is not allowed to walk away with any money. The lenders want every penny that they can get.
Sure they do.
And so if the lenders agree, then they walk away, they take the amount of money that they can get from the sale, and that's the end of it. The nice thing about short sales is from a tax standpoint, from an income tax standpoint, you're going to get, if you're the short sale seller, you're going to get a 1099 from the lender that says, you owed us $300, we only got $200, you have $100,000 in income. Well, I know that's hard to think about
Right.
that, but the IRS code says that forgiveness of indebtedness, or what we like to refer to as phantom income, is actually taxable. So under the law, under the Mortgage Debt Relief Act of 2007, if you do a short sale and you get that 1099-C for the difference between what the lender actually got and what was owed, you don't have to pay tax on that, provided it's your primary residence, up to an amount of $2 million if you're filing a joint return, or $1 million if you're filing a separate return. It works out well for you from a tax standpoint, because then you don't, before that Mortgage Debt Forgiveness Act was passed, if you did a short sale and you got that 1099, not only have you lost your house and any equity that you may have had in it, but now you got to pay a tax burden to Uncle Sam.
That's right.
And to the state of California. So the state of California has piggybacked that Mortgage Debt Forgiveness Act of 2007, and they say the same thing. Relief from indebtedness in California is going to match what the feds do. So you walk away from state income tax and you walk away from fed income tax. And that was a smart thing for the politicians to do, because we're in a crisis here in the real estate market. And to hammer people after they lose their home and make them pay taxes is not going to go over well with the taxpayer.
Exactly.
And you're probably never going to collect that money anyway. So that's a good thing. The other thing is there's a concept in California of a deficiency judgment, where under certain circumstances, if a lender forecloses, the lender could actually seek a deficiency for any money that they didn't get out of the foreclosure sale. But in California, there's been two recent pieces of legislation passed, one in January of this year and one in July of this year. And the January one said that if a first lien holder accepts a short sale, they can never get a deficiency. Well, that was great. And you know in your practice, so what happens is everybody says, well, what happens to the second lien holder? Because that's usually where the problem is. The first lien holder is going to get not all their money, but they're going to get close. The second lien holder is usually going to get nothing, or a pittance. So in July, after realizing how the market was actually working, the legislature passed another piece of legislation that says any lien holder that has loaned money secured by the property, any lien holder, first, second, third, you name it, cannot seek a deficiency if they accept a short sale. Now the key to that is they've got to accept the short sale. If they look at what you're offering and they say, we think we can do better if we foreclose and put it on the open market, then you're not getting the short sale and you're back into the foreclosure mode. And that's just the way it is. The lender has the ultimate say as to whether they accept it or not.
Speaking of which, in terms of, this is different from the last recession, the S&L crisis, where when families would lose their home, whether it's short sale or foreclosure, they could have that mortgage debt relief and bill collectors calling them.
Absolutely.
Okay. But now we still have today the homeowner associations, whether it's a planned unit development with single family homes or condos or townhouses. They need that money and they will come after it.
A lot of people think that if you get foreclosed or you do a short sale, let me back up and start with this. Usually when people are looking for a short sale or a foreclosure, they've stopped making their payments altogether. They're not paying the lender at all. A lot of times they're not paying the homeowners association either, thinking those go hand in glove with each other. It's not my problem, I'm not going to pay it, I don't have the money, I don't want to pay it. The problem is that the homeowners association dues are a personal obligation. The homeowners association, if you don't pay, can slap a lien on the property, but they don't have to. And that obligation is a personal obligation, and it can follow you around. I had a case not that long ago where my client had his condo foreclosed by the bank, but the bank didn't file the deed to the condo unit for months and months and months. Meanwhile, the homeowners association dues, which my client hadn't been paying all along, continue to run until the deed gets recorded. So then the homeowners association wrote to him and said, you owe us $10,000. And he thought, well, why should I owe you $10,000? I don't owe the property anymore. And so he said to me, well, I want to fight this. And I said, well, I got some bad news for you, pal, because those are personal obligations, and you're going to have to pay them. Now, you can try to negotiate that number down, But my experience is HOAs are hard up for money with this recession. They're hurting too.
Big time.
And a lot of them don't have reserves to do what they need to do under their bylaws and their charter. So they're not in the mood to negotiate. Now you could probably file bankruptcy and maybe discharge them in bankruptcy, but that's a pretty drastic act to do. So you're going to have to pay them. Now, what they will do, if they won't negotiate it down, is let you pay it out over time. As long as they get the money, they'll let you pay it over time.
Well, it might be the same. I remember showing property last year, and in the listing it said, in the private section for the agent said, buyer will pay the $10,000 in past due homeowner association assessments.
Wow.
Right.
Yeah.
And of course the house had been on the market a year.
Yep.
Townhouse rather. So that's a part, when I talked to the listing agent, the seller's agent about that the first bank and the second bank didn't want to have anything to do with that $10,000, right? So maybe it did go into foreclosure. What about in terms of credit? There's a difference you've mentioned in the past in your seminars doing a short sale. It's in the seller's best interest to handle a short sale for a number of reasons.
Right.
Versus a foreclosure.
Well, from a credit standpoint, the foreclosure and bankruptcy is oftentimes looked at as the kiss of death for your credit score because of the ultimate losses for the financial institution. A short sale is a loss for the financial institution, but not nearly as bad as a foreclosure. And so your credit score will get hit on a short sale approximately 70 points. So if you started with 600, you're at 530. A foreclosure, about 150 points.
Wow.
So that's a big difference because it's going to take some time to build that credit back up. You're not going to do it in a month. It'll probably take you a year or two. Well, if you're trying to build up 70 points versus 150 points, that's a tall order. Yeah. So it does affect your credit greatly. So there's another reason not to let the home go into foreclosure and try to short sale it, because of just what it does to your credit.
Well, it stays on your credit for 7 years, I know that.
Absolutely.
Now, in terms of the short sale versus the foreclosure, I know you've dealt with these banks before. That's a nightmare, isn't it, in terms of working with the call center? These loss mitigators or asset managers that they're called now, they might have 400 or 500 files on their desk.
Well, that's right. And part of the problem, and I've seen this recently in a couple of cases that I've worked on, where somebody thinks they're moving toward a foreclosure. Everybody's giving them the go signs. Everything looks good, everything looks positive. I think the bank's going to, internally, they're being told this by whoever they're talking to in the bank. It looks like the foreclosure sale, or excuse me, that the short sale is moving forward. And everybody's bullish on that. Meanwhile, the bank has started at sometime in this process, the foreclosure process, which marches on that 90-day and then that 20-day period. So what happened in the cases that I was involved in is the seller and the buyer were thinking that there was going to be a short sale and that had been approved, but they hadn't seen any paperwork yet. The bank hadn't issued the short sale approval letter, and the bank's foreclosure department went ahead and foreclosed on the property.
Wow.
And took it back. And so my client said, well, we want to sue the bank. And I said, you know, part of the problem is the banks have every right to postpone that foreclosure sale. Somebody has to communicate inside the bank between the short sale department and the foreclosure department to make sure that happens. Moreover, I think it's really important for the listing agent to make sure it's happening. Make phone calls to the foreclosure department if he has to the short sale department and say, give me some proof that this sale has been postponed. Because there are legal things that you could do to postpone a sale. It's not cheap, but you could do it to try to get the short sale to be completed. But if there's no communication with these departments and these monolithic banks, then you'll lose the property. And it's happened twice in probably the last 6 months that I've heard of, and that's I'm just one person. So I think it's probably happening fairly often. Now, had they issued the order and everybody signed it, issued the letter saying we approve the short sale, and then gone ahead and foreclosed, then you might have a pretty good case of setting aside the foreclosure. But at this time, it was just talk about doing the short sale, nothing in writing to prove it. I don't think you would win trying to set aside the foreclosure sale.
Well, that's just, it seems key to me in all the seminars that I've attended that's hosted by these banks and the bigwigs at their banks, is that it's agent error. The seller's realtor making errors is why the short sales don't go through.
That's probably true because, you know, in a lot of respects, doing the short sale, you have to supply so much information. Massive information, more than you did probably to get the loan to begin with.
That's what they say.
And so if you don't give them everything they're asking for, you give them 9 out of 10, then you're not doing your job as the agent. One of the things I would tell clients when they come in and see me about short sales, I say if you're going to choose an agent, make sure you choose an agent who is not cutting his teeth on your house.
Right.
Make sure you've got somebody who's done a number of these and been successful in doing so, because the stakes are really high. If you don't get the short sale, which is much more preferable to you, you're going to go through that foreclosure process.
Right.
Worse credit, then you're going to get evicted at the end, and that's sort of an ugly situation as well. Where you do the short sale, you can work something out with the buyer and give maybe a week to move out, that sort of thing. You can have some negotiation, but you have less when you've gotten foreclosed on.
Well, do you have any tips for these sellers involved with the short sales versus the foreclosures?
Always do the short sales if you can. Interview your real estate agent and see how many real estate short sales that person has done. And if they have a resume that shows how many they've done, even all the better, because again, you don't want them being, you don't want to be a guinea pig for the person doing it the first time. And I know in life everybody has to do things in life for the first time. You know, the agent could bring along somebody that he's training, and then they could learn that way. It shouldn't be on your time.
Right, and they always have the office manager.
Absolutely.
Great. Right. Roger, thanks again for coming out.
You're very welcome.
Thanks again for watching Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We will see you next week, same time, same channel. Thanks again for watching. Take care.